that the motion be... Oh, Paul Foster-Bell.
Sorry, Mr Speaker, I was a little bit slow off the mark there. Sir, it's a pleasure to rise and take a call in this first reading debate of the Evidence Amendment Bill, a very important piece of legislation being introduced in the name of the Honourable Amy Adams, our assiduous and hard-working Minister of Justice in this national-led government. Sir, evidence in our legal system is incredibly important, and it's a matter which this House does take, and I'm sure all members are of this view, does take with the utmost seriousness, given its important part in ensuring we have a fair and reasonable system for justice in this country. Sir, I was fortunate enough 2 weeks ago to be in Runnymede in Surrey for the 800th anniversary of the sealing by King John, and it's a myth that King John signed the Magna Carta. He did seal it. I was there for the 800th anniversary of the sealing of Magna Carta. And over that 800-year period since that momentous event, our legal system has developed many protections, checks, balances, institutions, traditions which provide for fairness. One of the very first times that it was actually put down in writing and became law of the land that people were to be judged by their own peers was contained in Magna Carta. And thinking of that, so I think that the way in which people are judged by their peers, by juries, comes down to how the evidence is admitted, whether the veracity of the evidence, but also how fairly that evidence has been obtained. And these reforms contained in this bill, Mr Speaker, do make a significant contribution to modernising the way in which evidence is treated in our legal system to ensure that fairness. Sir, I think just to go back to a general background, the New Zealand courts do follow the common law adversarial traditions in litigation, although there are exceptions, including the mediation process in the family court under the Family Proceedings Act 1980. So the evidence that is required to establish either a civil claim or to prove a criminal charge is presented to the court by the parties, and this is usually done through the calling of witnesses and the questioning of either the party's own witnesses or the questioning, the cross-examination of witnesses in the other side of the case. The very serious criminal charges tend to be tried by a judge sitting with a jury, as are a very small number of civil cases, and other cases, generally the more minor ones, whether civil or criminal, are tried by a judge sitting alone, and the judge's function in that particular regard is to preside over the hearing, to decide on the case according to the evidence and to rule as to the admissibility of that evidence. In a trial with a jury, however, it's the judge's function to determine the facts and to give the verdict. It's the jury's function to determine the facts and to give the verdict, and the judge's task is to direct them about the application of the law and to rule on the admissibility of the evidence and assist them with the summing up of the respective cases at the end of the trial. In neither civil nor in criminal trials may the judge or jury go beyond the evidence placed before them or accepted by the parties or embark on independent inquiry of the facts. This is a very important point, Mr Speaker, and it's been accepted. It was established most recently, I think, in the case of Queen and Jayasena, a 1970 case, which referred to Section 3 of the Ceylon Evidence Ordinance, which stated as follows, and I do think this is relevant in this case: a fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. So, sir, having established this background as to the nature of the law of evidence and where it comes from, I think the technical changes proposed by the Minister's bill, the Evidence Amendment Bill, make very good sense in modernising what has become a system that exists now in a very different world to that in which either that 1970 case was heard, and certainly a massively different world to the one in which Magna Carta was signed 800 years ago. So, sir, the purpose of this bill is to better protect vulnerable witnesses and to ensure that evidence is handled appropriately and securely and sensitively in the complex and technologically sophisticated world in which we live today. Sir, no government can ever legislate away the pain and suffering faced by the victims of crime. But this is a bill that will allow the more vulnerable victims and witnesses to be better supported through the judicial process and as part of a wider set of outcomes that this government is hoping to achieve, which put victims at the heart of the justice system through some of the new legislation that this government has stewarded through the House. The main provisions of this bill, Mr Speaker, improve the court processes for vulnerable witnesses. So we've actually brought in a presumption that child witnesses will be able to give evidence in alternative ways and will have the right to a support person. And I think this is incredibly important, Mr Speaker, for those of our smallest and most vulnerable citizens who have been the tragic victims of some of the worst offending you can imagine. It does strike me as odd that a judge would have to give permission that a child would be allowed to have a support person during the time in which they were giving their evidence to the court. It is also out of step, I think, with the world in which we live today, that those alternative ways of giving evidence were not automatically available to children. So this bill, replacing that former state of affairs in which the judge had the call, introduces a presumption that all child witnesses will have access to those alternative ways of giving evidence. For example, via the video recordings of a police interview or via CCTV, which is recorded from behind witness screens in the court. In adding the right to a support person, we do genuinely believe, Mr Speaker, that this will reduce the stress on those children who are giving evidence who may be the victims of some of that appalling offending. And we also think that this will help give more reliable and accurate evidence during the judicial process. There are some restrictions we're introducing to take into account the changing world in which we live, including restricting the Defence Counsel's access to the police videos of witness evidence in sexual and violent cases and of all child complainants' evidence. And the idea behind this, Mr Speaker, is to reduce the risk of those video records being misused or misplaced. So it's around the security, and one can only imagine how upsetting it would be for a young victim and their family to find that a video recording of their evidence had been accidentally left on a device, for instance, a laptop or a recording device that was disposed of by the court and somehow ended up in the wrong hands. But even worse, if there was a malicious case, and I think my colleague, my respected colleague Brett Hudson, the List member based in Oharu, referred to the horrific case of Clayton Weatherston, where a vindictive defendant actually used evidence that was provided in a cruel attempt to harass the family. I think in those particular circumstances, it is appropriate that the actual recordings are not left in the wrong hands, and there is an offence that we will be introducing in relation to the unauthorised possession, use and distribution of video record evidence in court. We are changing the notice requirements for evidence of previous sexual history, and I think this is only fair, sir, that when we're talking about bringing in someone's sexual history with another person other than the defendant, that advance notice is given. This is a change that was recommended by the Law Commission. I do believe it is uncontroversial in this House. It is very sensible and should be, I think, moved through. In terms of privilege, we are changing the privilege rules around plea discussions, and we believe that extending privilege to plea discussions, this is the sort of privilege that already applies to settlement negotiations and mediation in civil proceedings. We think it will enable a full and free plea discussion and encourage the earlier disposal of the case. This is a very good bill, Mr Speaker, and for that reason I commend it to the House.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it.
Evidence Amendment Bill, first reading.
The question is that the Evidence Amendment Bill be considered by the Justice and Electoral Committee. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. Joanne Hayes.
We've had a very busy week this week in the House, and so I seek leave to lift the House early.
Leave is sought for that particular course of action. Is there any objection from any member? There is none. The House stands adjourned until 2 p.m. Tuesday, 21 July 2015.
Thank you.